beyond sort of the aggressiveness of brands trying to enforce their trademarks, the biggest case right now, and one that's currently pending before the Supreme Court, is the Romag Fastener versus Fossil case. And for anyone who practices trademark infringement litigation and deals with damage issues, you'll know that this case is potentially going to settle a very significant circuit split. Specifically, right now, when you want to seek profit disgorgement, in copyright cases, if you show infringement, you can seek profit disgorgement as a matter of course. Of course, there's also the alternative statutory damage remedy if you've got a timely registration. Trademark cases are somewhat different. In trademark cases, and again, this is what Romag is dealing with, you can only seek profit disgorgement under certain circumstances, and those circumstances will often at least involve, depending on what circuit you're in, or require a finding of willful infringement. Specifically, 4 circuits right now have a hardline rule that there needs to be willful infringement in order to seek profit disgorgement. 2 others require a showing of willful infringement where the parties are competitors. And then the remaining 6 circuits consider willfulness, but it's not required. So in Romag, what you're looking at is a situation where Romag had sued Fossil and Macy's, claiming infringement of both their trademarks and patents in their fasteners. Fossil had been a client of Romag. They then went to another company selling basically the same fasteners, not under the Romag name. In 2014, a jury found that Fossil had infringed on Romag's trademarks and patents. And among the damages awarded were $6.7 million, which were the profits that Fossil had made in connection with the sale of products, including those fasteners. The district court refused to award Romag that full damage, stating, quote, "A finding of willfulness remains a requirement for an award of defendant's profits in the circuit." The jury did not make a finding of willfulness in that case. So that is on appeal. It's perfectly teed up. It's a ripe question that many of us that practice trademark infringement litigation are eager to get a clear answer to. And briefing was just filed this week, so keep your eyes out for that one. All right, let's switch over to Europe.
Before we do go to Europe, I do just want to say one thing. For me as a damages expert, the Romag case is really pivotal, because when you hire me, the first thing I have to know is what's going on with willfulness. And that leads to my entire proposal about what we're going to have to do to get the job done for damages. So no matter which way they decide, it actually impacts everyone, because either there's going to be more opportunity to go after disgorgement of defendants' profits, or there's going to be a lot more costs involved in figuring out what plaintiff's actual damages are going to be.
And if I can just add one more thing, I've really noticed over the last decade that copyright law and trademark law used to be sort of very different. And they've been coming closer and closer and closer together, right? Where an award of attorney's fees in a copyright case to the prevailing party was almost the rule rather than the exception. And then you get Supreme Court authority saying, well, you really need some objective unreasonableness, which brings it much more in line with the standard for awarding attorney's fees in trademark cases. And then on the damages front with the profit disgorgement, there's do you need willfulness? Should you not? I personally have been seeing, 2 areas of law, intellectual property law, with very different purposes, where your recovery and damages and attorney's fee, ability to get cost attorney's fees, have been really much more different than they are now. They're not the same, but they're coming closer together, and it'll be interesting to see how this feeds into that.
My shameless plug, I have an article coming out about this in a few days on the BHBA website, so take a look. Please, Vicki.
All right, so we're going again with Adidas, but this time in Europe, to see how they're faring with their trademark, their 3-stripe trademark. They originally, in 2014, were granted a trademark by the EU, but in 2016, the EU IPO said they failed to establish that they had acquired distinctiveness. And Adidas was appealing and to the general court, and the general court this past summer upheld the decision that these 3 stripes actually lacked distinctiveness. It wasn't distinctive in the entire EU, could not be seen as belonging to Adidas. So you have to keep in mind, when you think globally and are advising a client, that you have to take in consideration Europe may see things differently about different brands, and so that's a major one. And you think what could be more distinctive than Adidas's 3 stripes, and it's been pretty settled, but there they were upturned. So that was one of the new updates. Keeping with the sports theme, but moving on from trademark, we now have the Liverpool Football Club with their kit. They wanted to move on from New Balance to Nike, and New Balance had a renewal clause that they had the ability to match whatever offer a competitor would make, and they saw Nike's offer and they matched it, and they still lost because the court found that actually New Balance could not compete with Nike because they were able to pull in talent that New Balance could not, such as LeBron James, Serena Williams, and Drake. And they said that pushed it over the edge as you actually cannot compete. So the issue went down to contract drafting. Exactly how did you phrase your renewal contract and what you need to be aware of in your specifics of how you line up your terms. So that's something to keep. And actually, they just lost their appeal in November. It was denied. So Nike is now moving forward with getting the cake going.
All right, so moving on to copyright and social media. There have been a lot of high-profile cases involving celebrities. We'll talk about some of those. For me, I represent a bunch of designers. A lot of them I call Instagram darlings. And they're always like, oh, why can't we just take everything off of, social media, off of the Daily Mail and just post it on our Instagram? Please don't do that. Well, a social media expert told me that we could. And I'm like, when you're worried about whether or not you should actually do something, you should probably talk to your lawyer first. So, I always, tell them, don't listen to everybody. Nobody knows what the law is. Everything's fast moving. Please talk to a lawyer. Even if it's not me, just talk to somebody. So anyway, I'm sure we all know when dealing with copyright law, it obviously protects photographs, which is an original work of authorship. The holder of the copyright is generally the photographer unless he assigns it, or she. We've seen again with celebrities, can they post pictures of themselves on social media? Probably not, depending on what rights they have to them. Since we're being videotaped, I'm going to hold back on what I think of this morally. But anyway, so one of the big cases that came to light was this exposure versus Khloe Kardashian. And what Khloe did was she took a photo from the Daily Mail that she had not licensed. She removed the copyright notice from, so obviously it's on the Daily Mail. There's a copyright notice. You know who took the photo. You know who you have to contact. You know who you have to get to license. She cut that off and posted it on her Instagram. Obviously, the photo is valuable because we're talking about a Kardashian, in this case, Khloe. And, what happened was they eventually settled. And, she now goes ahead and licenses the photos.
Before you continue, I'm curious, Virginia, if you have any perspectives on this from a general counsel perspective at Goop.
I do, definitely. I'm curious, are there any in-house lawyers in the room? Oh, a few, good. So it's really interesting. I think obviously as outside counsel, you think about how obvious some of this stuff seems, and it seems crazy that someone potentially really high profile could make a misstep. And it's interesting, as Leslie mentioned, Gwyneth Paltrow is our founder and CEO and is a famous person and does a lot to promote our business, our beauty brand, our clothing brand, and is photographed at a lot of events in ways that could be very useful to our social media team. And so trying to educate a group of 22 to 26-year-olds about the fact that a photographer, not Gwyneth, owns the rights to her image in these circumstances is really challenging and is kind of a constant battle to help them understand as much as they need to understand without trying to over-lawyer every situation, but for clients, particularly in the LA market where I think a lot of us deal with a lot of these kinds of personalities, it's important to remember that it's not just the personality. In that case, it's very unlikely that Khloe Kardashian was actually posting her own image. It was probably someone on her team. But keeping in mind that you have to ask the question of your clients, okay, who's actually responsible for making decisions about what content goes where? Those are the people we need to talk to.